You come in, sir.
Yes, please.
Yes, please.
Good afternoon, sir.
Good afternoon. Ishant,
Yes, sir.
please have a seat.
Thank you, sir.
Ishant will kindly introduce yourself to the board.
Yes, sir. As you already know, sir, my name is Ishant Jaiswal. I belong to Kanpur, Uttar Pradesh. I completed my education from BNSD Shiksha Niketan Inter College, Kanpur. Thereafter, I completed my graduation in BLLB Honours from the West Bengal National University of Juridical Sciences, Kolkata. I am currently employed as Additional Civil Judge Junior Division at Fatehpur, Uttar Pradesh. And my interest includes listening to music, following field hockey, as well as badminton.
Very good.
Ishant.
Yes, sir.
Oh, your optional is law.
Yes, sir.
That is very good. And you are also employed as
Judge, sir. Additional Civil Judge Junior Division at Fatehpur, sir.
it is through exam.
Yes, sir. PCSJ exam.
Okay. That is state government.
Yes, sir.
There is exam for these appointments now.
Which exam, sir?
No, they are state level exams.
Yes, sir. There is a PCSJ exam for the lower judiciary.
Lord Judiciary.
Yes, sir.
That is, and is there some exam at higher level?
Yes, sir. There is a HGS exam by the respective high courts of the nation.
High Court. At
Yes.
national level, there is no exam.
No, sir. There is no All India Judicial Service.
You
as
are
of now.
aware of the amendment, no? Constitutional
Yes, sir.
99. What was that about?
Sir, NJAC, sir.
NJAC.
Yes, sir.
And what was the provision in that?
So basically, so in third judge's case, the Supreme Court gave the collegium system. Then the amendment was done to include NJAC, in which there was a panel of 6 members, including CJI, who would select the basically the Supreme Court and the High Court judges. So this was done, but it was struck down by the Supreme Court in the 4th judge's case.
Panel of 6 members included CJI.
Yes, sir.
And who else were 5 members?
So there was 2 members appointed by the central government. There was also a. Sorry, sir, I am not able.
You're not aware. It was 3-3.
Yes, sir. 3 from judiciary side, and 3
including
from.
CJI being the chairperson,
Yes, sir.
and 3 from executive.
Yes, sir.
Was it that?
Yes, sir.
And it was struck down.
Yes, sir.
Do you think that judiciary is exceeding its limit in defining the separation of power, and it is in the name of basic structure of constitution, it is hijacking the constitution?
So I think in this case, judiciary did so. I think in
No, in
basically-
this case defines their absolute arbitrary power.
Yes, sir.
So is this correct?
So Supreme Court has been protecting rights of the citizen for a long time. We have seen in the case.
That is right.
Yes, sir.
But through this case, did they protect the right of general citizen? Do you think that separation of power theory is protected? What is the basic structure of constitution in the first place?
So
Please define.
there are some important rights and laws, which basically there are some important provisions in the constitution which should not be, which should always be followed and should not be amended.
Is the basic structure defined specifically?
No, sir.
This
It was
is not.
given by Supreme Court in Keshwananda Bharati case.
Okay, it was given. Why
Yes.
it is not defined specifically?
Because, sir, Supreme Court gave it in the case.
Because Supreme Court can take advantage of basic structure principle in the case based on their choice and wish. Can that be said?
No, sir. I think Supreme Court did right basically in what happened in.
No, if they did right in the NJAC case, it was based on the basic structure principle that Supreme Court acted arbitrary and they put the judiciary above the executive. Is that right or not?
So in this particular case, I think the Supreme Court should have taken more. Basically, in no other countries there is a provision where judges appoint judges. We have seen that how much nepotism has been there in the Supreme Court.
So do you agree? And then still you are coming back that in this case,
So-
now this is the crucial case. What should have been the appropriate method by which it could be resolved? NJAC versus collegium.
So I think NJAC was a better choice, but Supreme Court basically said that it violated the independence of the judiciary. So the better position would be.
This statement was this not arbitrary? And could that not, suppose Supreme Court thought that their right on appointment, placement and transfer was disturbed, so they could have done some suggestion to NJAC
Yes, sir.
and
They
then
could have
gone
done so.
further. Instead of doing the suggestion, there could be a committee of Supreme Court and executive, because otherwise it disturbs the principle of separation of power, which is the basic structure, one of the basic
Yes, sir.
structure. So in the name of basic structure, they disturb the basic structure.
Sir, yes, sir. So basically, they did some judicial overreach in this case, sir.
Okay, so this judicial overreach was the worst damage done to the country's democracy.
So firstly, there has been so much basically nepotism in the High Court judges and Supreme Court judges. Then also there has been a delay in appointment.
No, I don't need any further. Now you have agreed with that, so we can stop at that.
Ji, sir.
You are from law, you are a law student,
Yes,
but the basic principle, basic structure, all these things, your concept should be fully clear.
Yes.
And also what the judiciary has done and what should be done. That-
Yes, sir.
Okay, all the best. Thank you.
Thank you, sir.
Mr. Ishant,
Yes.
now you know International Court of Justice
Yes.
is an arm of the UN.
Yes, sir. Yes, sir. It is an organ of UN.
So, do you think that it has got any role now?
Sir, ICJ has a role to play. So in nuclear in the advisory jurisdiction of nuclear weapons also, it said that nuclear weapons should not be allowed. But I think the problem is that ICJ decisions are not binding on the court, on the member nations. So it could be enforced only between the members who put up their case in that court. So this is the problem. But I think still.
More and more cases are coming in the International Court of Justice involving international violence,
Yes, sir.
isn't it?
Yes, sir.
And they are giving judgments, but nobody cares.
Yes, sir.
It goes to even Security Council, vetoes. What happened with Israel? Netanyahu, Ben Gavir,
Yes, sir.
they were convicted by ICJ on the basis of their report.
Yes.
President Putin.
Yes, sir.
What's this requirement?
So ICJ needs some reforms also. So in
Now,
the
even if you reform, do you think that an organization, if it does not have any power to enforce its jurisdiction, enforce its rulings, does it have any role?
so its judgment have persuasive value. So
Which value? What value?
persuasive value. So
Persuasive.
Persuade whom?
so two countries that are there in ICJ.
But what happened? It gave a ruling that Israel must allow aid convoys to enter Gaza.
Yes.
What persuasion?
Yes, sir. So this is the problem. Basically,
So it doesn't have any persuasive power.
So in some cases it has, but the one there is.
Can you give me one example where ICJ's rule was observed?
Sorry, sir, I'm not able to recall right now, sir.
There is none. Okay. Now, who brought the case against Israel in the ICJ?
So South Africa brought the,
It was supported by whom?
supported by sir. So I don't know the exact country.
Who gave the most convincing? Who made the most convincing arguments at the Hague, ICJ headquarters at the Hague, which led to this judgment?
Sorry, sir, I'm not aware of it, sir.
That Irish lady, you have not seen her?
No, sir.
And any other country which has joined very recently in that?
Sorry, sir, I'm not aware of it, sir.
Cuba has joined.
Yes.
Okay. Now, what is the position of ICC, International Criminal Court?
So, International Criminal Court situated at Rome. It was it doesn't include it only includes individual crimes, not the state crimes. So, if only individual can be prosecuted in this court and not states. So.
Do you think that current international relations
Yes, sir.
are based on law or rule-based or law-based?
So I think the current international relations have been basically transactional and based on economy and what is best for the nation rather than the rule based.
So it's not rule-based.
Yes, sir.
Ishant,
Yes, sir.
what is the role of Kanpur in the freedom struggle?
Yes, sir. So Kanpur has played a great role in 1857, the first war of independence. There was a case of where Nana Sahib fought British general. I'm not able to recall his name. I'm unable to recall his name, but sir, I think he was Hugh Wheeler. Hugh Wheeler, sir. Yes, sir. So there was a case that happened in siege of Kanpur happened, in which many Britishers were killed and they were thrown into the well, and also sir, there was another war fought by the Taत्या Tope also in 1858, but he couldn't be successful in that.
Okay. So now, what was the first ever coded law?
Sorry, sir, I don't know, sir.
Okay, I'll give you a hint.
Yes, sir.
Byzantine Empire,
Hammurabi codes. Sorry, sir.
Justinian codes.
Okay, sir.
That was the first ever coded law.
Yes, sir.
Must read about
Okay, sir.
Emperor Justinian's code. Okay. So suppose I was ask you to suggest
Yes,
some reforms in the lower judiciary
yes, sir.
and the systems and processes which are followed there.
Yes, sir.
Tell me what 5 to 6 reforms you would immediately suggest.
Yes, sir. Sir, there are a few reforms that can be done. Firstly, there is a serious crunch of infrastructure. So in my court also, I don't have basically desk for putting the computers also. So this is the serious case. Secondly, sir, there has been a serious crunch of staff also. So many judges don't have the steno or the reader so that they can proceed their court. Thirdly, also there has been the problem of implementation of laws. So some laws are not implemented, such as plea bargaining, which has been given in CRPC or also by Bharatiya Nagrik Suraksha Sanhita, but they are not implemented. Same also, sir, most of the decisions are given in the routine manner rather than applying the principle of the law. They are given in the routine manner also. So these are few suggestions
How many opportunities should be given to an advocate to take adjournments on flimsy grounds?
So there is a provision in CPC which allows 3 adjournment only, but
Never happens.
Yes, sir. So Supreme Court in Salem Bar Association case said that this is only basically not mandatory, and it is not possible that judgment could be done in 3 sittings. So that's why three sittings. So that's why it gave the judgment in the Salem Bar Association that it could be basically end this. I think there should be some limit to this. The advocates do bring frivolous ground that I got ill or the plaintiff has not come.
Okay. So now, how many cases are pending in lower judiciary, High Court and the Supreme Court, and what can we do to just bring the pendency to 0?
Yes, sir. So there is currently 5 crore cases pending in India. I think in Supreme Court it is 80,000, and in High Court of Allahabad it is around 2 to 3 lakhs. Sir, I am not aware of the exact figure. I know about the UP judiciary where it is around 1 crore cases are pending. So the steps which I would suggest is, firstly, judicial vacancies there. So in India, we have the sanction strength of 24,000 judges, but there are around 60,000 judges, and that sanction strength is also very low. Secondly, sir, I would suggest that alternative dispute resolution should be done, such as mediation, conciliation, which are not being done. So our existing provisions, such as I already mentioned, plea bargaining and as well as compounding offense, are generally not followed in the lower judiciary, which could be done. Also, sir, for reducing pendency, we can use the technology also. Technology such as there has been serious progress in this, such as e-court mission mode project has entered its third phase, and also there has been portals such as the CIS portal, where the judges have to basically put their, they have to enter their judgment in those also. So then also there is a serious problem of infrastructure that I already mentioned. So one, as already suggested by previous CJI Ramanna, that we could build a judicial infrastructure authority also, which could build infra crunch in the system. So these are
Okay, but I've never heard anyone talk about zero pendency.
Sir,
Nobody has given that mission mode concept to the entire judiciary. Why?
so maybe because it is not possible, sir.
Okay, why should the justices be still called lordships and ladyships and whatever?
So I think it is a colonial hangover. It should not be called. The proper mention of sir and ma'am is enough, sir.
Okay. And has there been an order like Mr. Trump issues executive orders?
No, sir.
No. So that means they still want to be called lordships.
Yes, sir.
Okay. Okay. What are your hobbies?
Sir, I love to listen music and follow field hockey, sir.
Which music?
Sir, I generally listen to various genres, but my favorite is old Bollywood music, sir.
Old.
Yes.
So what's the difference between Bollywood songs say up to 1975, 76 and today?
Sir, today's music focus mostly on beats rather than.
Okay. And the previous one?
Sir, previous one was more focused on the lyrics of the lyrical depth as well as the melodies of the.
One thing you are missing, the most important thing. They were based on
They were based on, sir,
rag.
rag, sir. Yes.
How many rags are there?
No, sir, I don't know, sir.
Oh, you don't know. You must, if you're fond of
Yes.
old music, you must know which song has been sung in which rag. And for what particular time of the day or night was it meant? Okay, we end your interview here. Tell me, how did it go?
Sir, sometimes I basically got cornered in some discussions.
Why?
Such as,
Why did you get cornered?
sir, I was unable to basically counter it.
No, you're not supposed to
Yeah,
counter
that's-
it.
that's
You're
okay.
supposed to answer it.
Yes, sir. Okay.
This is not a court, no?
Yes.
That you're discussing and
Yes.
countering, giving counter argument.
Yes.
You're a good candidate, but your approach to the whole deliberation should be different, no?
Yes.
You
Sir.
need a paradigm shift. We are here to help you to understand your personality.
Yes, sir.
If you know what are the parameters of personality, you have done law, you have appeared in one more interview earlier. No?
Yes, sir.
UPSC, how much did you score?
Sir, I scored very less, 149, sir.
149. So you forget that this is a court, no? In the interview board, that is not a court. That is only examining or seeing your personality, how you are doing, whether you will be suitable for us civil service, no?
Yes,
Government service. So that is it. You have already done your written, everything you have done. You have been selected for interview. So you should concentrate on gaps in your knowledge and also personality improvement.
Yes, sir.
You should be natural, spontaneous, and pleasant. You know,
Yes,
in
sir.
the interview, that is the requirement. And on the issues, no issues of constitution, law, budget, everything, you should be very thorough.
Yes, sir.
Okay. All the best.
Yes, sir.
As he has rightly pointed out, the way you answered is not the way you should give answer to the board.
Yes, sir.
You have fixed ideas. You do not seem to think out of the box.
Yes, sir.
Like, an advocate is pleading. It's not.
Yes.
It's a civil service.
Yes.
At a very high-speed bullet train, you are just answering the question from, I do not know the answers, whether you have prepared already or not. The moment you are off the track, you are off.
Yes.
ICJ, the moment I went to which
Yes.
country, you said South Africa, that was right. Actually, who pleaded for that? The South African Irish lady,
Yes.
35 years of age.
Yes.
You should know it.
Yes.
Cuba has joined last month.
Yes.
Why they joined? Why Ireland joined? They think out of the box. Why Ireland joined? That's what I'm saying. You are not thinking out of the. Why Ireland joined of all the countries? Why South Africa launched it? Why? Just think of it. You are not thinking.
So I think they feel that the atrocities against Gazans.
It's not atrocities. The word has been used apartheid.
Yes.
Israel is practicing apartheid in
Gaza.
Gaza. South Africa suffered under apartheid regime,
Yes. Sir.
isn't it? Okay. Ireland
Yes.
was subjugated under the
British also.
England.
Yes.
English at that time it was England.
Yes.
It was not Great Britain.
Yes.
It isn't it? That's why. So think out of the box.
Yes.
It's not a standard answers.
Yes.
Is international relations, current international rule based? You simply say it's transactional, this, that, no. It is, your simple answer is, it is not rule based.
Yes.
Because various type of rules, international rule, had it been rule based or law based order, same yardstick would have been followed in all the cases.
Yes.
As same yardstick is not followed in all the cases,
Yes.
it is not rule based or law based. I have not asked you whether it's a transactional, this, that. Some words, that answer is prepared answer. Please note that the board is here or will be there is to select an officer.
Yes.
Okay, who will take a decision, not from, he shouldn't carry baggage.
Yes.
You are carrying legal baggage. Anything could be, music could be your optional paper. We don't care.
Yes.
But you shouldn't carry baggage. You are carrying baggage of your legal background.
Yes.
What is in law, this. And on many occasions I have noticed that you have contradicted yourself,
Yes.
especially in legal cases.
Yes.
Isn't it?
Yes, sir.
Didn't you contradict yourself? Do not contradict. Answer your question not from your stock answers. You must have prepared some stock answers and you are giving the answers like that. Please don't do like that. Otherwise you will do fine.
Yes.
You will score up. But there has to be a paradigm shift
Yes.
of your approach to the board.
Above all, think on the spot.
Yes, sir.
See, coached, prepared, parroted doesn't make sense.
Yes.
Be original, be yourself, you are very good.
Yes.
And no need to say, as you are aware, I am Ishant. No, we are not aware. Maybe we have taken your name. But,
Yes.
so,
No, he said, as you know.
as you know.
As you know. Yes, this is the
I
word.
think I said as you already know.
As you already know.
Yeah. So there's no need for as you already know.
Sir, my name is
No
Ishan Jaiswal.
preface, no preface.
Okay.
Try to be as natural as possible.
Yes, sir.
In the whole thing. This, as I said, this is not a court.
Yes.
It's not a courtroom. You are not giving argument and counter argument. No, you forget. Come out of that mindset.
Yes, sir.
When you are a judge
Yes.
and in witness box somebody is there and you have to, what is your name? As you are aware, my name is He doesn't say so.
Yes, sir.
My name is so and so. This is this is my schooling. This is my education, higher education. This is my hobby. This is presently what I am engaged in. This thing matter ends. Thank you. But you have to make a paradigm shift. Anything from your side?
Sir, so
you
I
wanted
called
to ask something.
yes, sir, in judicial basically so am I allowed to basically point out the mistakes of the Supreme Court or the High Court?
Now, young boy, now is the time to be free
Yes, sir.
and correct in your response. No, are you defending the judiciary?
No,
Do
sir.
you plan to defend judiciary?
No, sir.
Your duty is to speak the correct thing,
Yes, sir.
because this is there for everyone to see. It is an open judgment.
Yes, sir.
Okay, so open judgment, even courts have changed their judgments.
Yes, sir.
What is the meaning of 5-4 judgment if there is a division? 5 judges have one view, 4 have another view, and there have been so many judgments that way.
Yes.
So are they doing anyone who is differing? Are they criminals? Are they doing a crime? They are expressing their views.
Yes, sir.
So you have a right to express your view.
Yes.
That is it. And you are seeing with your open eyes, you are understanding with your open knowledge of what law you have done, that what is truth, what is false, what is right, what is wrong.
Yes,
You
sir.
should express yourself.
यहाँ
But
पर
once you take But once you take a stand, don't contradict yourself.
Yes, sir.
Yes,
जैसे
please.
कोर्ट में होता है ना कि ट्रुथ को अनट्रुथ से कवर करो,
Yes.
यहाँ सब कुछ नहीं है. नो डिफेंड नो.
Civil service is different. Now you understand how they have let the court go with the atrocity in that Constitution 99th Amendment. That is it.
Yes.
Because they have patience, they want the court to understand their mistake and come up with solution. Ideally, they should have suggested that time the solution and gone for the correct way
Yes.
out. Okay.
Yes.
All right. Yeah.
Thank you.
गुड लक.
Good luck.
Thank you, sir.